What's up, you guys? Thank you for watching Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. We have been blessed with an update from the Clayton County Georgia police on the now infamous Ring doorbell arrest video that was brought to the public forefront by Abaya Israel from the We the People University channel, and also publicly commented on by John Bryan, the civil rights lawyer. They did a great job of going through the facts of that case, and since that time, the Clayton County Georgia police have come out and given us an update as to what they think. But just in case you've forgotten what happened in that case, let's just go back to the highlights and let them explain to you what their position on the case was.
OCGA 16-7-23. Criminal damage to property in the second degree. A person commits the offense of criminal damage to property in the second degree when he intentionally damages any property of another person without his consent and the damage thereto exceeds $500. OCGA 16-10-24. Obstructing a police officer. Except as otherwise provided in subsection B of this code section, a person who knowingly and willfully obstructs or hinders any law enforcement officer in the lawful discharge of his or her official duties shall be guilty of a misdemeanor. On December 15th, 2023, officers of the Clayton County Police Department responded to an address in College Park, Georgia, concerning a report of damage to property. At that location, officers spoke with the victim, who reported that there was an ongoing dispute between her and another female who has repeatedly trespassed on her property. Following an earlier dispute, the female, accompanied by 4 others, returned to the victim's residence and caused significant property damage. The suspects smashed the windshield and front headlight of the victim's vehicle, and the suspects rammed another vehicle into the victim's vehicle while it was parked, leading to more damage. 2 of the suspects then kicked the victim's front door, causing additional damage. The incident was captured on video. Over $5,000 in damage was reported by the victim. The victim advised that a male who remains anonymous provided transportation for the females to the residence. That male agreed to guide officers to the location where he dropped the females off. Officers relocated to the location where they observed a vehicle matching the description of the vehicle used to ram the victim's car parked behind the house. Officers also encountered a female at the house who had been at the previous house where the damage occurred based on video from that location. While investigating the suspected vehicle at the house, a male walked to the vehicle, at which time officers began questioning him about his knowledge of that vehicle. The officers' body camera footage began as officers are checking the secondary house for the suspects and suspected vehicle.
77 Pine Guy Drive 2. That one. That's it. Oh, that's the tag right there.
I'm confirming y'all are at that address.
Yes, ma'am. Also, can you copy your tag as well? Is this one?
Go ahead with it.
Out of Alabama. 3 Adam 0 2 Nora Young 7. Yeah, because she said Salora. Hey, brother, who car is this? Yeah, who car is this?
Today's come back. It's no stolen. I'm showing it on a 2008 Toyota Camry Blue.
Is that dog chained up?
Showing valid.
Okay. There won't happen to be no damage. Yeah, whose car is this? Sounds about right. Look. Yep, they're right there. Can you answer the question whose car it is and why it's in the back?
Hey, pretty, hey.
Yeah. Is this your car? Hello? Gotcha. Keep him right there.
Right, I'm just trying to figure out why.
Hey, so that blue car that she was talking about is parked in the backyard of his house. Yes, and it has black paint transfer as well. That matches that black Chrysler. And also the lady wrote down the tag, has the exact same tag on there as well. So,
17, go ahead with it.
buddy, no. Initially, I thought it was that one, but that's the blue car right there. So there it is. And it has a tag on it. I took a picture of the tag that she wrote down. And she did describe a blue car as well, but I thought initially she was only talking about that blue car, but it is that one as well. Well, apparently it's a guy in the back
25.
who's not answering no questions. How you doing, man?
Comes back to a Raynard Huffman,
What'd you say?
a Renard, RE1.
Well, for one, I'm sorry. My name is Officer Pickens, Clayton County Police Department. This is Officer Ho. This is Officer Smith.
Baby, what's up, baby?
How you doing today?
I'm good.
You okay? You stay here?
Listen,
You don't stay here? Where you stay at?
I stay in Dunwoody.
Dunwoody? That question.
I have friends. I can't have friends.
I didn't say that. I just asked you a question.
I have friends.
Okay, so where your friends at?
And I don't know.
You don't know?
I'm not,
Yeah, he right here. I see him.
Hey, who was driving that vehicle?
I'm not sure.
I mean, obstruction is a beautiful charge. It is.
Obstruction of what?
Our investigation. I mean, you kind of do have to talk because, again, obstruction is a hell of a charge. I mean, you kind of do have to talk because, again, obstruction is a hell of a charge.
Oh, yeah.
Because I'm in the middle of an investigation, so if I ask you for your name, you ain't got nothing to do with what? So you're not going to give me your name?
Why do I need to give you my
Because I'm in the
name?
middle of an investigation, I'm asking you
I
a
have
question.
nothing to do with that.
But I asked you a question, so what's your name?
You can step down.
So how you know what we talking about?
You can step
I
down.
have nothing. You're talking to me.
You don't have to, but you can step down.
I came from the back.
Exactly.
Because,
So
again,
let's
if you go in that house, you're going to jail. Both of y'all.
What?
Why?
For what?
Like
Obstruction.
I said, we're in the middle of an
Obstruction
investigation.
of what?
Because we have an investigation going on.
Man, stop.
That vehicle right there is involved in our
It's
investigation.
not mine.
Okay, so I'll say that then.
I did.
Not ours.
So who's this? We asking one question.
So who is it?
Why are you being so hostile right now? We just asking one question.
Man, quit playing.
Is this not your house?
What's your
No,
name?
it's not my house.
Okay,
What's your
but
name?
understand, if
Not
you
my
step
house.
if you take a step inside that door,
Right, okay.
I will drag you out and put you in handcuffs.
Okay.
Try
What's
it.
your name? What's your name?
Right.
You're not
Watch
going to give
this.
us your name?
Watch this.
Please don't do that, y'all.
Watch
Name?
this. I dare you to take a step inside the house.
So you're not going to give us your information?
No, hold on. Wait. Let him just do it.
No, I have a provider.
Ma'am? Ma'am?
You don't even know your own passcode. That's crazy. Is you sure this is your house? Hello? So, you do have a duty to identify yourself when we ask, especially while conducting an investigation. I want you to understand that. Please listen to that as well, ma'am. The second thing is, again, that car back there.
You can go ahead.
My brother, hold on. Hey, whoa.
Yep.
All right, hold.
Turn around. Turn around. Turn around. Turn around.
Don't worry.
Turn around. Turn around.
Bro.
Turn around. Turn around.
I can't.
Turn around.
Okay, turn around.
Ain't nobody touching you right now. Turn around.
Bro,
Just ain't nobody touching you right now. Turn around.
I can't speak.
Turn around.
You want me to
Turn around. Turn around. Get on.
Compliant?
Get. Ain't nobody touching you. Turn
You want
around.
me to be
Get
compliant?
on your stomach.
Right.
Get on your stomach.
So you want me to be compliant?
Get on your stomach.
You're not even listening.
Last time. Get on your stomach.
Listen. Get on your stomach now.
Get on your stomach.
Oh. Wow, y'all brother.
Why are you doing that to him?
Two Trevor 21.
I'm not understanding why you're doing that to him.
Don't worry about it. Don't worry about it.
Go ahead.
Start supervisor out here.
For use of force. Making sure you tell for use of force.
For use of force, please.
Go ahead, you clear on it.
I don't think he even knows
Go ahead.
what's going on.
Go ahead.
One location for supervisor request.
I
I cleared out. I told her that. Good job.
No, we're not. We asked him a
But I
question.
didn't, ma'am, I'm not even saying anything. I'm just asking. I ain't even asking anything.
Two Trevor 21. Show one in custody, please. Also, can you start affording my location?
Check him because he had something.
I'm clear.
I'm clear and just making sure you have at 5677 Pine Gate.
I'm pulling. I'm pulling.
Action on me, my brother. I
Relax.
was in the car.
Relax.
I'm not trying to do anything, bro. I was in the car.
Two driving 21. What's the injury?
Small alteration to the front face.
I'm gonna get in the car, my brother.
Commander 10 unit. Give me a public
Go
service,
ahead.
please.
Sit down. Take a seat.
That's how I'm here.
I'm gonna see how you gonna get away with this one.
People just need to learn Georgia law. I'm telling you exactly how I'm
What's
getting.
Georgia law, bro? What's Georgia law?
I'm explaining to you.
Right. Can I
Yep.
get my phone call?
Yep. Go ahead.
Right. I don't even know what this word is.
I'm about to explain it to you because I tried to, but you didn't want to listen.
You gonna be dead wrong, but okay.
Watch this. Watch this. Close your
Watch
foot.
it. Let's watch it. Go.
So again,
My brother,
you asked me to. You asked me to explain something. I explain.
What's the charge?
Obstruction. Failure to
What's the
identify
charge?
yourself. Those are two charges right there.
What? Obstruction of what, bro?
Our investigation, which I tried to
Obstruction of
explain
what?
to you.
What's the charge? I ain't got nothing to do with your investigation.
Good job.
What's the charge?
I already told you. Hey, did y'all copy that 69? Hey, it's bro, ho. If she don't want to talk, bro, put her in handcuffs too. She can go as well. Simple as that. It's bro, ho. If she don't want to talk, bro, put her in handcuffs too. She can go as well. Simple as that.
was. Okay, so the very best version of the facts for the state are basically that they're undertaking a felony vandalism investigation. They've gotten some insider information. They know who the informant is because the informant admits to dropping one of the suspects off at this particular address, right? So they believe they've got some information as to this person being dropped off here. All right, so they've got $5,000 worth of damages. They've got a person who was intimately familiar with at least the removal of the suspect from the primary crime scene to the secondary scene, and they are essentially trying to justify the investigation that's undertaking. But what actually ends up happening is the police are at a neighbor's house, and they're in the neighbor's driveway when they locate what they have corroborated as being the suspect vehicle. They run the plate, or they had the plate from previous information, and they match that plate. So they did have information that car was the car they were looking for. They see this vehicle parked in the back of the house where the Ring video arrest happened. So they have a plain view. Officers are viewing this from a lawful vantage point. They corroborate the suspect vehicle. They find it at this house, and so they walk to the back of the house, and they are corroborating the information on the vehicle, taking notice of some paint transfer and things like that, when they encounter a male also in the backyard, and they attempt to try to interrogate him, and he doesn't want to cooperate. Okay, so that's basically where we are. The police officer then leaves that area of the backyard, comes back around front, and joins the other officers where they are interviewing the female. The male that was initially being interviewed by Officer Pickens comes back around the other side of the house, and he's standing on the front porch, and from different views of video, we know that he basically told the female that she doesn't have to give them any information or participate in their investigation, and that's when we hear Officer Pickens say obstruction is a hell of a charge, it's a beautiful charge, whatever. So that's their best case scenario. They are justified in being there because they have a felony investigation. They have information that the vehicle should be there, that the suspect was dropped there. They see and corroborate that that's the suspect vehicle in plain view, and their intention, I guess, is to further their investigation. But let's see how their case holds up through the process of cross-examination, because that's what's fun about the law, right? We don't just have to take their story or take it at face value. We get to cross-examine the witnesses against us and the things that we're accused of, and so let's have a little fun and cross-examine this situation. So the first thing I would ask is, what are the requirements under the plain view doctrine for the state in order to justify a warrantless search? And so there was actually a recent case, United States versus Mejia Velasquez, a United States District Court for the Northern District of Georgia, that basically reiterated what we all know to be true, which is that the home or the curtilage of a home is presumptively unreasonable to be searched in the absence of a warrant. However, one exception to the warrant requirement is plain view. So what are the elements of plain view doctrine? The law officer has to be in a place where they're lawfully allowed to be. And in this particular case, we don't know whether the officer was in a place they were lawfully allowed to be. What we do know is that the officer was at the neighbor's house. And even if the officer is not supposed to be at the neighbor, the people in the house over here that's being investigated, they don't really have standing to object to the police violating the neighbor's Fourth Amendment right. So we can assume that they're from a lawful vantage point. They're in a place where they're legally allowed to be. So they're at the edge of the neighbor's driveway, and they can see behind the house the vehicle in question, and they can visually match the license plate number. So that's the first element. The second thing you have to have in order to do a plain view seizure or a plain view search is you have to have a lawful right of access to the thing that you're going to search. And then the third thing that you have to have is you have to know that the unlawful nature of the thing that you're going to search or you're going to seize is immediately apparent. So in this particular case, you probably have a lawful vantage point, or at least one that can't be contested by the people in this house. You are able to corroborate that the unlawful nature of the vehicle is immediately apparent because they're matching the license plate, right? But what about that second element, that element of a lawful right of access? You don't have that here because the vehicle is in the curtilage of the home. It's in the backyard. And not only is it probably curtilage just based on the obvious circumstances, but just the fact that they're making the argument that the vehicle is being hidden behind the house would tell an objectively reasonable person that they wouldn't hide something in a place that they didn't feel like they had a reasonable expectation of privacy. And so if you were to make the argument that this part of the house is not the curtilage, I don't know how you can do that and also say that these people were hiding this car so as to keep it from being detected or take it out of the public view. You either have put it in a place where you have a reasonable expectation of privacy, i.e. the curtilage of your home, or you didn't. And they're going to accuse some folks here of hiding this car behind the house and then ignore the fact that that means that there's a reasonable expectation of privacy in the place that they just hid it. So in plain language, going into these people's backyard, if the court were to consider this the curtilage, would be no different than walking uninvited into their living room and begin to start interviewing people and demand their identification. So that's the first thing. The second thing is they're making the argument that the gentleman in question is somehow obstructing, based on the fact that the OCGA obstructing code that they laid out in the beginning of their video basically says that you can't hinder or obstruct an officer in the course of his investigation. But they ignored the lawful discharge part of the language of that code. And it's impossible to be in the lawful discharge of your duties if you've walked essentially into someone's living room uninvited and without a warrant and started undertaking an investigation that you didn't have a right to undertake. You can't, for instance, absent exigent circumstances, you can't see a pot plant growing in a window and then just walk in the door and arrest somebody. You can't do that. You have to get a warrant for that. You can use that as the basis for probable cause for the warrant, but you still have to get a warrant. And so this is really no different. Seeing a vehicle behind the house in a place that was clearly established for a reasonable expectation of privacy or within the curtilage is no different than seeing something through a clear window within the four walls of the home. You need a warrant to access that. That's where the lawful right of access comes in under the plain view doctrine. You may see it from a public street or from a lawful vantage point, and you may know that it's illegal. But without a lawful right to access to it, you can't do anything about it in the absence of a warrant. Now back to the obstructing. There is a long line of case law in Georgia, and unfortunately Georgia is still, I won't call it a stop and ID state, but in the state of Georgia, unlike a lot of other states, where you have enough reasonable articulable suspicion that you could perform an investigatory detention of the person, you may ask for their ID, and if they do not give it to you, then it can be considered obstructing under Georgia law, and that's been upheld under numerous appellate cases in Georgia. However, here's the problem. They're basing their reasonable articulable suspicion on a misleading piece of information that can actually be disproven by watching the video. So in their rendition of the facts, they state that a male in the rear of the residence approached the vehicle. But if you actually watch the video, you'll notice that as the video is playing, the officer is communicating. He has in real time corroborated the license plate, and the officer breaches the curtilage of the home and approaches the side of the vehicle before the male is there. And then if you look at the video, the vehicle is here, the corner of the house is forward of the vehicle, and then the man walks beside the house in a straight line, and there's a dog over here chained up, which becomes part of the conversation that Officer Pickens tries to have with the person who's ultimately detained here, and he starts asking him about the dog. Well, if you actually watch the video, the man does not move towards the vehicle in any way. The man moves straight towards the dog, and then the officer makes contact with the guy, and that's when the guy starts looking the direction of the vehicle and the officer, because the officer's beside the vehicle and the guy's forward of that. So there's actually nothing in this. There's no facts that would indicate that this guy's involved in this. He does not go towards the vehicle, despite the fact that they misleadingly allege that that's what happened. They don't have any actual reasonable articulable suspicion to even tie him to the vehicle in any way. So I don't think that their points hold up to cross-examination in this particular case. Plain view, you don't have the second of the three elements that you need, a lawful right of access. Obstructing, you don't have because A, you don't really have a reasonable articulable suspicion to tie him to any crime, and B, you're not in the lawful discharge of your duties because you're already standing in the curtilage conducting a search in the absence of a warrant or consent or any exception to the warrant requirement. Next, we explore whether or not these people can be charged with obstruction simply because they didn't answer the officer's questions. Again, when it comes to obstruction charge, it is true that if the officer does in fact have a reasonable articulable suspicion under the Terry standard to make an investigatory detention, you are required under Georgia law to identify yourself. However, you're not required in any way to answer any of their questions, ever. That's a Fifth Amendment constitutional right to not participate in your own prosecution. And if you knew the percentage of evidence that is used against people in criminal prosecutions that comes directly from them, I can tell you from firsthand experience, people think that they can talk their way out of things and they can't. And a lot of times they will say things to police officers trying to explain their position on something, not even realizing that they have made themselves look even more suspicious, and instead of dispelling the officer's suspicion, they've actually elevated that officer's reasonable suspicion or unreasonable suspicion in some cases, elevated it to reasonable suspicion, and then that gets elevated then to probable cause, and they end up getting prosecuted. They're submitting interviews, they're answering questions, they're trying to be cooperative, and it's all because they don't want to be accused of being uncooperative with the police, because nobody wants to be the guy who, everybody thinks is hard to get along with. But the truth of the matter is that police officers generally have an idea of what they suspect happened before they start asking questions, and so it's very difficult to dispel an officer's suspicion once they've decided that they're suspicious of you. And it doesn't actually have to even be anything that you've done to make them suspicious. Police officers are suspicious by nature because their job is to, as they see it, detect crime and enforce laws. So the answer is it's not illegal to not answer questions. There was no basis for him being threatened with arrest simply because he told his friend not to cooperate in the investigation, nor was there any basis for her being threatened with arrest simply because they didn't want to answer questions or participate in the investigation. And Officer Pickens again makes a comment towards the end of the video, something to the effect of, well, she don't want to answer questions, we'll just hook her up and she can go too. And it's obvious retaliation for invoking a person's Fifth Amendment right. So here's the information you've all been waiting for. The major that's in charge of the patrol division for the Clayton County Police Department in Georgia came out, did a press conference to update the public and the news media on the status of this investigation. And while I'd like to tell you that he came out, was accountable, and said, these are the things we're going to do better, and these are the things we're going to try to get right that we may not have gotten 100% right, all he did was double down on bad police work. He victim blamed and suggested that the person who was whose face was bashed off the wall and had a cut, an abrasion over his eye, and who probably had a concussion as he stumbled back into the house where he was an overnight guest, that he could have made things easier had he just cooperated and given the guy's ID.
All right, start off by giving everyone my name. I'm Major Anthony Thuman. Spelling on my last name is Thuman. It looked like T-Human if it's typed correctly. I'm the Uniform Patrol Division Commander here for the Clayton County Police Department.
On Friday, December 15th, approximately 5:20 p.m., officers responded to 5600 block of Wynwood Road in College Park to a disturbance call. Upon arriving and investigating, they found out that it had been an actual physical altercation, as well as some damage to property that exceeded the amount making it a felony. Officers were able to develop information on suspects, and the suspects had left the scene and gone to a different location. Victim was able to provide a video and was able to provide a tag number for the suspect vehicle. Shortly thereafter, the officers located the suspect vehicle concealed behind a house on a nearby street. As officers went over to verify the vehicle, there was damage, tag number, things of that nature. Male subject came from around the corner of the house, at which time the officer engaged with male subject in conversation. Male subject claimed not to live there and engaged with conflicting information. Officer went back around to speak to his fellow officers that were on the scene up front, which time there was a female in the front yard they were speaking to as well. The male from the back then turned around and came to the front and interjected himself in that conversation as well. The male refused to identify himself or provide any information, kept going to the front door, at which time on the video that has been released, you can see it here, where the code is being punched repeatedly trying to get in the door to know that the male claims he does not live there, but again will not give any information. The officer told the male not to step inside, and be arrested, moved to go inside the house, at which time my officer grabbed him, taking him to the ground, and he was placed in handcuffs. On the way to the ground, the male stepped aside the door, at which time on the video you can see that he sustained slight injury to his right temple. The male and female were detained based on further investigation and were subsequently released pending further investigation based on our criminal investigation.
Are there any questions?
Can you talk more about what that conflicting information was? Were they saying that they knew the person there? Were they saying that they just wanted the neighborhood? Are you able to tell us any of that information at all?
I'll go into a little bit of it here so everybody knows. I don't want to go into a whole lot because both these cases are still actively being investigated, but there was some information about whether or not he actually resided at the home. It was, no, I don't. Yes, I do. Yet he knew the dog well enough in the backyard to tell the dog to sit down, and the dog complied. He came around punching information in and saying, no, I don't live here. I live in Dunwoody. He kept punching in the information. He would not give anything other than, like I said, the conflicting information.
And just to be clear, they were questioned because they matched information that was given by someone else in the neighborhood in reference to another incident?
That is correct. The incident did not occur on the property where you see the video. It occurred at a different property. The car matched the information. The car was captured on video and was verified via the tag number, via some paint transfer on the vehicle, the description of the vehicle, things like that.
The owner of the home where the ring camera video is, he explained to me that the people in the video were guests at his home. Has that information come up at all in your investigation?
That is not. But again, our criminal investigation is conducting that investigation. I'm here to speak to you today as Uniform Patrol Division Commander because the people you see on the video are the Uniform Patrol Division.
In that video, sir, one of the officers makes note several times that he is going to try and arrest this person for obstruction charges. Under what guise did he have the right to arrest him for obstruction, given what we saw in the video?
A couple of different things here. When the male subject comes around the house, and which time you see on the video, on a couple of the videos, because keep in mind, there's only a snippet of one video that is down. There's multiple videos of the other officers on there. The officers are actually speaking with a female in their front yard, believed to be a suspect in this felony offense that we're investigating. This male immediately comes out and says, you don't have to talk to them, and interjects himself into the investigation as well as not wanting to give information about the car and things of that nature.
What's the interaction within your policy?
Yes.
Even the verbal?
Even which part of the verbal? He said a lot.
The verbal where he kind of pretty much says, I will put you in a headlock or whatever the verbiage that he used to let the man know.
I don't believe he was ever threatened with being put in a headlock that I recall from seeing it. I think he told me he would take him to the ground and place him under arrest. He did tell him that. Yes, we do a verbal contract. We can tell someone if you fail to comply that there will be consequences, and that is to protect the suspect as well as the officers that are out there. That's to protect everybody. That's not just solely for the officers.
If that officer had to go before a judge, testify about what happened that day, and the judge were to say, where was the obstruction? Again, what portion of that video was their obstruction exemplified?
There's several different issues in the video. One of the things I want to reiterate here is please keep in mind the video that has been released, not by our department. There's a portion of it released by our department. It does not depict the totality of everything going on. It is not just that we came into a backyard and this man was in a backyard and all of a sudden he wouldn't identify himself. That's not it at all. You had a vehicle involved in a felony offense that was concealed behind a house at night. Subject came around and says he does not live there. Now, please keep in mind, the preliminary information he gave my officers was he does not live there, but he's inside the house. He doesn't want to give, or he's at the house. He's trying to enter a home that he's already told us he doesn't live at. He's refusing to dispel any of the officers' concern. There's multiple issues that could have arose here. So obstruction was what the officers say on the video, and there is an element of obstruction in accordance with what the code section says.
Is there any investigation happening, I guess, with the conduct of the officer, or is there any review happening of the incident right now?
Absolutely. Anytime our officers are involved in any kind of incident in which a force is utilized of any kind, okay, it goes through a full command review. It starts at a shift level and comes all the way up through the assistant chief and the chief of police. So there are multi-tiers of the review. So not only do we review the tactics, we review the conduct, we review the language, we review everything. We're very transparent about that.
Just playing devil's advocate for the public here, because that video has been seen by a lot of people. You know, I think the concern that a lot of folks had was not necessarily a violation, but questions about a person's Fifth Amendment rights when they're interacting with police, and the fact that citizens do have the right to remain silent and have no obligation to participate in an investigation. You know, can you understand those concerns? Where was that right lost in this interaction?
I certainly understand the concerns. I don't agree with the fact the right was lost in any way, shape, or form, because there was a little bit more to this.
Bro, if she don't want to talk, bro, put her handcuffs through. She can go as well. Simple as that. I mean, you kind of do have to talk because, again, obstruction is a hell of a charge.
Okay, and you absolutely have the right not to self-incriminate. You absolutely have the right to remain silent. You do. There's things on this. There also are times that you need to identify yourself to officers when the officers are going through something of this nature. What's interesting to me in the video is this could have been avoided by the suspect if the suspect had complied and just merely identified himself. There was conversation that is later on in the video with his in the back of the car. The officer fully explains why he's there, what he's doing, things like that. The suspect fully still refuses to identify himself. So it could have been. I understand the concerns. I've read the comments that are on Facebook. I've seen what people are saying. Okay, but I also understand the suspect's actions dictate the actions of the police officer.
Was it true that he lived in Dunwoody?
We've received conflicting information about that. That's one of the things that the reporter asked me about here. We have received conflicting information as to where he actually resides. And again, that's stuff that our criminal investigation division is following up on.
And again, the man's not facing any charges as of right now.
He is not charged with anything currently.
And the female?
Don't know.
And the female also not facing any charges?
Not right now. Like I said, they have not been charged with anything formally.
Have there been arrests made in the original case of the place that got broken into in the car and all that?
I don't really want to speak on that because that's outside my purview. Okay. This is with criminal investigations following up. I'm sure that our PIOs will release a final statement if there are charges brought forth.
So you were saying there could be charges at a later time for these two people?
I'm saying there could be. Yes. Thank y'all very much.
My other question was, why did you all feel like you needed to come out and kind of speak to these allegations? Because obviously videos like this do make their way on social media pretty frequently in today's era. Why did you feel like you needed to defend yourselves, I guess?
I thank you for asking that question. I tell you, it's not coming out with us trying to defend ourselves or us trying to defend our officers' actions. What is important for us is for the Clayton County Police Department to be transparent in what we do, to show that we have nothing to hide. The actions of the police officers are what the actions of the police officers are, whether they are good, whether they are in compliance with policy, or if there's some deviation. If there's deviation, we handle it. But we want to show everyone we are absolutely transparent. There is nothing that we do that was not open to questioning. When the video came out from the other group that highlighted and there were some accusations in, we wanted to ensure that was answered. Thank you very much.
Thank you, sir.
Here's the biggest problem with that. At the end of this video, we find out that these people don't get charged with anything. And so if I put on my prosecutor's hat and I'm sitting here thinking my way through this case, and I'm trying to come up with a way that I can prosecute this case successfully so Officer Pickens is my officer, I'm the state prosecutor, we're at preliminary hearing. And I ask Officer Pickens, what exactly did him not giving you his identification keep you from investigating? I mean, we're charging him with obstruction, right? So if we're going to explore an obstruction charge, I need you to be able to tell me at least one thing that you weren't able to accomplish or learn or investigate. What lawful discharge of your duties were you not able to do because you didn't have this guy's ID? Because remember, he doesn't have to answer your question. All he has to do is give you ID. So what about his identification made your job easier? Because eventually, remember, after we bashed his face off the brick wall and we put him in handcuffs and put him on the ground, and then we talked to him like he wasn't a middle-aged man because we're a 20-something punk, arrogant police officer who thinks they can do whatever they want, they can talk down to people. So once we had him secured in the back of the car and we treated him like he was a child, we figured out who he was, right? So we got his ID. And you want to know what became of that identification? Nothing. Absolutely nothing. I would have dismissed this case in 30 seconds as a prosecutor, because you don't have an argument for obstruction where you eventually find out who the person is under duress or because you bounced his head off the wall, and that gave you absolutely nothing towards the thing you were trying to investigate. Now, again, he wasn't even charged, and so that's where I think this is a failure on the part of the police department. There wasn't anything about him not giving the ID or having given the ID to Officer Pickens that would have made any difference whatsoever as it relates to figuring out whether or not this vehicle was parked there by somebody who was the suspect in the ultimate vandalism. This guy was in no way connected. There was no description of a male suspect, nothing like that. He's just there. Wrong place, wrong time, overnight guest. And overnight guests do have standing and a reasonable expectation of privacy in the place that they are. But you got to keep in mind that they don't ultimately bring charges because they know they can't prove them. Because at the end of the video, they go on to say that they were ultimately released without being charged, which means that they have to admit, in the same way that they have to admit there's a reasonable expectation of privacy back here in the backyard if you're going to accuse them of hiding something back there that they didn't want you to find, we also have to admit that him giving you the ID made no difference whatsoever and thus had no obstructive effect on your ability to investigate. And so that's why he wasn't charged. And that's why if he had been charged, any prosecutor worth their salt would have dismissed this case in 30 seconds. So my verdict in this case is that this is poor police work, an arrogant police officer that escalated this encounter for absolutely no reason. He's sitting there being so condescending. He'll ask a question, he'll say, hello. Like, he's trying to start an argument. This behavior out of a police officer who talks to people this way is either going to lead to him being assaulted in the line of duty, indicted, or fired, or all three. And ultimately, where Clayton County missed the mark is that they need to talk to this kid, calm him down, get him to understand that this is not how you conduct investigations. You don't break the Fourth Amendment and stand in somebody's virtual living room or curtilage while demanding ID from people that you can't link to a crime without a warrant and then go pretend like you're justified in doing so. And unfortunately, as modern policing dictates, many police departments are way more concerned with telling the public that they did it right than they are with actually doing it right. And that is the reason that there's been a continuous erosion of public trust in the institution of law enforcement. So anyway, thank you guys for tuning in. I'm sorry it's a little long-winded. Special thanks to John Bryan and Abaya Israel for their analysis that kind of helped me frame my argument about this case. Check out their videos. Check out the video on the Clayton County, Georgia police page. While I'm glad that they have addressed it and they didn't just let it go, I think it really was more because Abaya Israel used to work in a neighboring county and they didn't like the fact that he ostensibly was taking a shot at them. And so I don't think it was really about transparency. I think it was more about being in a pissing battle with him. But either way, they gave us an insight into the way they think, which is that, again, they're more concerned about being right than they are about getting it right. And so that's where I land on it. Hey guys, listen, I'm trying to build the channel up. I started this channel a few years back and kind of stepped away from it as I pursued my career. Now we're just trying to build it up. So please comment, like, and subscribe. I appreciate your support. I'm just calling balls and strikes, calling the case the way I see it. Reasonable minds can and will differ. And so it's my opinion. It doesn't matter to anybody other than, whoever agrees or disagrees with me. But it's fun to have the conversation. And it's important that we have the conversation. And it's important that we understand each other's perspectives. So stand up for your rights. Always record interactions with the police, if for no other reason, just so you have documentation of an event that nobody else may have, and stay safe out there.